Hello students, welcome to KANISHKA IAS. As a part of the question to concept approach, in today's video we are going to discuss about the broad differences between due process of law and procedure established by law. The very context for this particular topic is the 2023 preliminary question. In essence, due process of law means 4 options have been given. One is fair application of law, principles of natural justice, procedure established by law, and equality before law. This particular question was asked. And moreover, we can expect such kind of questions in future also pertaining to Article 21. If you try to look into Article 21 textually, it reads as, no person shall be deprived of his personal liberty and life except according to the procedure established by law. So, in fact, if we try to get into the Constituent Assembly debate, in which certain members of the Constituent Assembly have insisted to include due process of law in the place of the procedure established by law. Then Dr. B.R. Ambedkar has raised his concern that if we include due process of law instead of procedure established by law, the hands of the judiciary will be strengthened. Moreover, we are going to implement landmark legislations and land reforms, distributive justice, etc. This will be hampered by the judiciary because of the excessive power that will be handed over by this particular term, due process of law. Hence, they have dropped the term due process of law and included the term procedure established by law. Now, let us understand how these two terms will be differing from each other. In fact, the question pertaining to due process of law versus procedure established by law for the first time has arisen in A.K. Gopalan versus State of Madras, in which the preventive detention law was questioned. A.K. Gopalan was a communist leader. He was arrested in the manner of preventive detention, and he has approached the court under habeas corpus petition, that is under Article 226 of the Constitution, initially to High Court, later to the Supreme Court, under Article 32 of the Constitution, where Supreme Court was supposed to examine this particular Article 21 and explain whether under the Indian Constitution whether due process of law is applicable or not. Then the primary question A.K. Gopalan has raised was, sir, I have been arrested under Preventive Detention Act so that my personal liberty has been violated. And he says, if any violation of Article 21, that must be justified according to Article 19 also. Why? Because Article 19 talks about liberty and Article 21 also talks about liberty. It means A.K. Gopalan tried to present his argument this way, where the fundamental rights cannot be treated in the individual sense. They must be taken in a kind of wholesome manner or integrated manner. It means any deprivation of one article must be justified under another article also. So, in other words, if my right is violated under Article 21, that violation must be justified to be reasonable under other articles also. And moreover, A.K. Gopalan also says, the law, if it is lacking in its procedure, if the law is unfair, if the law is arbitrary, if the law is subjective, in that scenario, it is the responsibility of the judiciary to correct under the concept of due process of law. But however, Supreme Court has rejected this argument. It stated that under Indian Constitution, we do not have the concept called as due process of law. Rather, we have only procedure established by law. Moreover, Supreme Court also said that Article 21 talks about personal liberty, whereas Article 19 talks about liberty. The personal liberty is different and liberty is different. Personal liberty is a safeguard only against the physical restraint, and if it is satisfied by the procedure established by law, then the physical restraint will not be illegal. So, in other words, if there is a law enacted by the legislature, even though it is arbitrary, even though it is unfair, if it is constitutional, the deprivation of the personal liberty is justified. It need not be justified under Article 19 of the Constitution, which talks also about the liberty. So, this is how Supreme Court for the first time has rejected the very basis for the application of due process of law under the Indian Constitution. Later, the same kind of question, the similar kind of question has been raised in Maneka Gandhi versus Union of India case. In Maneka Gandhi case, Maneka Gandhi post to the emergency after the fall of the Congress party government, Janata Party government has applied this Passport Act, Indian Passport Act. There is section 30 clause 3 subclass C of the Act permits the passport officer to impound means withholding or taking the passport into their custody of any person under public interest. Hence, they have impounded the passport of Maneka Gandhi. Then Maneka Gandhi has sought reasons why you have impounded my passport. Then the answer of the administrative agency is that we are following the procedure established by law. So that is the law of the land, that is Indian Passports Act. And moreover, the Passport Act does not clearly specify the reasons. It only mentioned it is a public interest. Then she challenges the order of the passport officer in the Supreme Court, stating that, sir, Article 19 talks about movement of a person within the territory of the country, whereas the movement outside the country is covered under Article 21. In other words, Article 21 is not merely just life and existence, it is also something related to dignity. It is also something related to personal autonomy. And moreover, she also argued that the fundamental rights are integrated in nature. We can't give any isolated treatment to the fundamental rights. It means if any law which is to be applied or which is to be regulate the right of the individual, the same law must be justified according to other article of the Constitution. So she wanted to provide or prove that there is an integrated relationship among all the fundamental rights under the Constitution, especially between Article 14, 19 and 21. Then Supreme Court has examined this matter very deeply and it has identified the fundamental lapses in the Indian Passports Act. What is that, If you are impounding the passport of any person, you can't impound the passport in the arbitrary manner, in a biased manner. Just like that, show the man, I will show the rule. The rules must not be varying from one person to another person. And the procedure you follow must be transparent, must be fair, must be enhancing the confidence of the people over the law. But unfortunately, no such evidence can be seen from this particular act of the administrator. And what is the defense of the administrator? He simply says, sir, the law provides me procedure, I am simply following the procedure. When the law is constitutional, my exercise and application of the law is also constitutional, because I am subjecting myself to Article 21, and if you try to read Article 21 textually, it speaks only about procedure established by law, but nothing is mentioned as far as due process of law. Then the Supreme Court for the first time held that the law and application of law, both the substantive law and procedural aspect of the law, must be fair enough. It means law just need not be constitutional, it must also be procedurally fair. Simply you understand, the judiciary under Article 21 of the Constitution has the power to see that the executive agency must be performing its functions according to the law of the land. Okay, the limited ambit of Article 21, especially with respect to procedure established by law, does not permit the judiciary to investigate whether the legislature has enacted the law in a fair manner or unfair manner. Its purview is only limited because Article 13, Class 2 of the Constitution permits the judiciary to examine, that is the judicial review, only to see that the law must not be inconsistent with the fundamental rights. But the judiciary has no mandate to say that the law enacted by the legislature is fair or unfair, the law enacted by the legislature has procedural correctness or not under procedure established by law. Because of the invoking of the due process of law, judiciary got the power to examine the law both constitutionally as well as procedurally. In other words, the judiciary has emerged to be a super legislature. It means the legislature is the one which makes the law, but in case of any correction, who is supposed to make? Legislature itself. But because of the due process of law, judiciary has got the power to correct such kind of potential errors as far as the procedure is concerned. In other words, Supreme Court said, if any law lacks the principles of natural justice, it will be the power of the court to correct that particular law. Then what is principles of natural justice? Principles of natural justice will help in the fair application of law. In other words, the principles of natural justice means such principles, such a moral and ethical framework of the individuals, which will be identifying what is right and what is wrong. Of course, there are certain universally agreed principles of natural justice. That is, no man is the judge of his own case, no man shall be condemned unheard, absence of bias, justice not only be done but also appear to be done. So if you follow these principles, any or every application of law will appear to be fair and just. No person will be feeling that he is subjected to bias or subjectivity. And people will also be gaining the confidence over the law, and that will be enabling or facilitating the people to comply the directions of the law. So that's how Supreme Court said, just you are mentioning in the name of public interest, you are impounding the passport, it is not correct. What the administrator has to do, the administrator has to follow principles of natural justice. It means you need to clearly communicate why your passport is to be impounded. You need to give a notice. You need to give a fair hearing. You need to give a fair opportunity to give the right reply for the allegations you are making. So this is what the Supreme Court has clarified. So it means not only the executive action will be questioned, but also the law itself will be questioned if it is not having the procedural correctness. And when we say the law is lacking the procedural correctness, if it is not following the principles of natural justice. So in other words, principles of natural justice will give the procedural fairness as far as the application of law is concerned, procedural correctness. And moreover, Supreme Court also for the first time agreed with another important point which was rejected in the A.K. Gopalan case, stating that Article 14, Article 19, Article 21 are interrelated. In other words, the fundamental rights are having the integrated approach, they are not isolated. If any law which is violating one article, or if any law which is regulating one particular article, must be justified by another article as well. So in other words, if there is a law which is taking away Article 21 of the individual, must also be justified by Article 19 of the Constitution. For example, Article 19 Class 5, which says public interest must be the reason to deprive a person for his free movement throughout the country. The similar reason must be applicable under Article 21 as well. So that's how Supreme Court for the first time has taken a fundamental shift from the procedure established by law to due process of law. And Supreme Court further and further expanded the scope of Article 21, and which became the basis for the future cases. For instance, the Puttaswamy case. Article 21 is being expanded by the Supreme Court to include many things. Right to travel abroad, as it is given in the case of Menaka Gandhi case, right to dignity, right to medical assistance, right to speedy trial, right to legal opportunity. That's how the scope of Article 21 further expanded because of the Supreme Court's interpretation of procedure established by law to be due process of law. So that's why due process of law encompasses broadly the principles of natural justice, and the outcome of the principles of natural justice would be the fair application of law. The procedural fairness will be leading to the fair application of law. That's why the answer is principles of natural justice. And further, Supreme Court has identified the essence of Menaka Gandhi case even in the Puttaswamy case. It further said that when the law will be justified, means it again given three important principles. So in fact, under the Constitution of India, no fundamental right is absolute. Every fundamental right must be observed in terms of reasonable restrictions. In fact, in India, the fundamental rights are qualified in nature. But however, just because they are qualified in nature, you can't be taking away these particular rights in the arbitrary manner. That's why Supreme Court in Puttaswamy case held that if any law is to be justified to regulate the fundamental right of an individual, it must be able to pass three important tests. Number one, the law must be legal. Legal means there must be legality. There must be law which is constitutional. That is number one. Number two, it must be needed. There must be need or necessity for that particular law. Just because to target some individual, you can't bring any particular law. And number three, there must be proportionality. So it means the law must be having the proportionate reason. For example, when you are targeting a stronger person and you are targeting a weaker person, both cannot be receiving the same pressure. Okay, the pressure must be proportional to the capacity of the individual. That is nothing but proportionality. Suppose you are inserting a nail onto the wall, the pressure will be different. Suppose you are toppling a particular wall completely or collapsing a wall, the pressure would be different. That's how proportionality test must be followed. Okay, so that's how the due process of law became the reason for the expansion of the Article 21 of the Constitution to include multiple rights which are related to dignity of the individual and protection of the right to privacy. That's how the right to life will become wholesome but not fragmented. So finally, we need to make some summary of the discussion we have made so far. That is, procedure established by law means the executive will be upholding or implementing the law as per the dictations of the law. Whatever the law says, they will be just following. But due process of law empowers the judiciary not only testing whether executive is following the law, it will also be testing the very law itself, whether the law is procedurally correct or not. In case of any incorrectness, the judiciary will be taking the power to correct such law. So that's how the judiciary is acting like a super legislature. Instead of just restricting itself to regulate the executive, it will also be entering into the domain of the legislature. That's how judicial activism can be seen by the application of due process of law. In other words, the judicial activism means what? The proactive stance of the judiciary to protect the rights of the people and protect the constitution by enforcing other organs or by making the other organs to function according to the principles of the constitution. Thank you. For more videos, please follow KANISHKA IAS.